Good morning. Welcome to the Judicial Committee of the Privy Council, where this morning we are hearing an appeal from the Court of Appeal of Trinidad and Tobago in the matter of Clarke and others against the state. The appellants, Clarke, Martin and McGilvary, were convicted of manslaughter. The question for consideration is whether their convictions are unsafe on the ground that the defence at their trial was prevented from cross-examining the key prosecution witness about certain statements he had made. I'm Lord Lloyd Jones, and I'm sitting today with Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
Lord Stevens.
Good morning.
And Lady Rose.
Good morning.
The appellants are represented by Mr. Michael Birnbaum, Queen's Counsel. The respondent is represented by Mr. Rowan Pennington Benton. Mr. Birnbaum.
Yes. May I begin, please, with 2 points of information which I've mentioned to my learned friend. The first is, I felt that the board may want to know the dates which have been fixed for the adjourned hearing of the appeal on the third trial where Boudram and others were convicted of manslaughter. Those dates are the 1st, 8th and 10th of June, when that appeal will be heard. The other point I thought that the board may want to know about was why there was no count of kidnapping on this indictment, as there would have been in the equivalent trial in this country. And I think that the reason for that is not a matter of choice by the respondent, but rather that in Trinidad, as in almost every other jurisdiction in the Caribbean, they do not join in the same indictment capital and non-capital offences. I can go into the reasons for that if need be, but that is the simple situation. And it may have implications when your lordships consider the justice of the case, to which I shall come towards the end of my submissions. Can I say that as far as possible, I want to take the facts as read, and when I give references, I shall try to avoid taking the board to the original documents unless you wish me to do so. In my additional submissions, I have sought to raise a more fundamental point, because originally I was simply going to argue that the question that we're looking at, which is the background to Rodrigue making his statements, went only to his credit. But it occurred to me, frankly, for the first time only when I was compiling my most recent submissions, that actually this was something that the jury should have been told about from the very beginning, because it went to the issues in the case, namely how Rodrigue had come to be a witness at all, and secondly, any possible motive that he might have. And I was particularly struck, looking again at the well-known case of Chan Wei Kyung, by what Lord Mustill said, and this can be seen at page 1598 of the bundles, where a witness is called who may have something to gain by giving false evidence, it's necessary that what his lordship called the potential fallibility of that evidence should be put squarely before the jury. And my first point is that that should have been done from the very outset, even in the opening of the case. Now, may I explain that? The background to this case is remarkable and I would imagine unique. Summarizing it as swiftly as I can, Sanday was kidnapped on the 27th of November 2005. She was assaulted and buried according to Rodrigue in quite short order a day later. On the evening of the 7th of December of that year, Nigel Allen disappeared. He left his home and was not seen again. As we now know, Rodrigue was closely involved with the planning and execution of both kidnaps, and indeed he played a confessed part in the killing of Nigel Allen. On the 16th of December, Rodrigue went to the Couva police station with significant injuries, and they included bore holes to his ears and cigarette burns to his body. He went to tell the police what was clearly a pre-planned account of how Nigel and 2 associates, whom he described in some detail, had kidnapped him and held him a prisoner for a number of days. He went into considerable detail about routes that the kidnappers took when driving him from one place to another, the tortures that were inflicted on him, the food that he was given day by day, and how he came to escape. It's not clear whether the two accomplices of Nigel Allen that he described were real people, but perhaps it doesn't matter very much one way or another. So he gave that false account on the 16th of December to the police, to whom he had gone, as an injured complainant, as it were. But by the 19th, the police had found the body of Allen in a shallow grave very near to where Rodrigue lived. I interpose to mention that, in fact, they had in the meantime seen Rodrigue's co-defendant, Wendell Simmons, who had told them what had really happened, and they found the grave as a result. On the 20th and the 21st of December, Rodrigue made two further statements, in each of which he confessed to being the man who'd arranged the kidnap at the behest of Junior Sammy, and he gave an account of the killing of Allen. He said 3 times that the "I was kidnapped" account was false, and it turned out that the cigarette burns were self-inflicted. He was charged with the murder of Allen on the 22nd of December. On the 31st, he gave a very detailed account of the kidnap of Sam Day, which your lordships have, albeit only in the manuscript, the assault on her and her burial. In early January, arrests were made on the strength of what he'd said, and 10 men were charged with capital murder. 1 of the 10 was discharged at the preliminary hearing. This sequence of events must surely be unique. A man who's gone to the police to tell them a pack of lies about how he was kidnapped by someone whom he himself had kidnapped and killed ends up, in quite short order, as the principal witness against a large number of other men in respect of another kidnap which had led to a killing. Moreover, he himself is closely connected with that other kidnap, that's the one of Sam Day, and must himself have been an accomplice to it. I ask rhetorically, how likely is it that such a thing has ever happened before in any common law jurisdiction? The respondent's argument that the jury should not have been informed of this extraordinary sequence of events is absurd. It's offensive to both common sense and justice. Let's leave aside for the moment, if we may, the cross-examination of the credit question. Surely the jury needed to know about the events I've outlined for 2 reasons. First, because they were an essential part of the narrative of events, to explain how police came to know the story about Sam Day, which Rodrigue was going to tell. How did that come about, that story crystallized? Secondly, because it was important as demonstrating his mendacity. And more importantly, because it went to his motive to fabricate evidence against others. Why? His motive was arguably this: that having failed to row himself out of the Allen kidnapping, he'd ended up being charged with the murder. He was now in a terrible fix, and he would have reason to volunteer information about the Rampasang kidnapping killing, whether it was true or false, in the hope that the more people he implicated, the better his chances would be of securing favorable treatment on the Allen murder. The more people I can get into it, the better for me. Moreover, prosecuting counsel, as I point out in my additional submissions, is a Minister of Justice. He's obliged to ensure as far as he can that the jury know the moral stamp of the witness on whose evidence 9 other lives are going to be at stake. And that obligation would be all the more pressing in this case, because Mr. Peterson, the prosecuting counsel, had been at the committal and knew that Rodrigue was a man who'd said, in effect, that he would lie to get himself out of the fix. He'd been extremely, almost disarmingly frank about that. And I ask the board to consider the converse of this. Let's just suppose that Rodrigue had gone to police on the 16th to tell them the truth about the Rampasang saga. and he'd immediately made a detailed statement about it. In other words, suppose he'd said on the 16th of December what he was later to say on the 31st. I've got a story to tell you, I must tell you, even if it gets me into trouble, I can't keep this to myself. I know what's happened to Sanday. I even know where she's buried. Surely the prosecution would adduce that evidence as part of their case. It would be an important aspect of the case for two reasons. Firstly, to inform the jury of how they came to know of what had happened. But secondly, because there would be a powerful argument that that sequence of events made it the more likely that his story was true. The argument would be, why would he put his head in the lion's mouth? Why would he subject himself to the possibility of being accused of all this if he was going to tell a pack of lies against others? And so that is the point which I invite my lords to consider, the board to consider first of all, whether this evidence should have been before the jury anyway. And if I'm right about that, it had the advantage the prosecuting counsel could open it, warts and all, to the jury, and it would make counsel's position, and indeed Rodrigue's position, much less difficult when it came to cross-examining him, because the jury would know the relevant parts beforehand. Suppose I'm wrong about that. We come now to the point upon which I actually have leave, or I think it's these days permission, I should say. And that is cross-examination as to credit. And I'd like to begin by saying a word in fairness to the judge, Mr. Justice Nareen, who coped manfully with this problem. He was plainly extremely concerned to make a fair ruling. But although counsel before him were very able and very experienced, I must say in fairness to him that it does not seem to me at least that he was very well served on this particular point. They should have sought his ruling before Rodrigue got anywhere near the witness box. That's what counsel would have done in this country, I'm sure, if the facts had been anything like these. But as it was, Mrs. Elder, a very able and capable barrister, was in the middle of her cross-examination when the judge interrupted her and said, well, where are we going? And one might have had the impression that she was not immediately prepared to argue the matter, although she did argue it eventually very well. It would have been much better if this had been ventilated carefully by everybody at the outset, and then a more proportionate and more fair resolution might have been adopted than that which the judge eventually came. Having said that, can I now come to say a little bit about the common law as to cross-examinations to credit? The argument here is that Rodrigue could be readily cross-examined without imperiling him in any way in relation to the Allen murder on the untruth of the statement of the 16th of December, because he had conceded its untruth in three passages which I've set out in detail in my argument in my case in his statements of the 20th and the 21st. The fact that it was a fabrication of a kidnapping is not really the point. The point is that it shows, this saga, his capacity for elaborate fabrication. And the point would be equally powerful if he had fabricated, let us say, a blackmail plot or a fraud or something of that kind by Allen and his two henchmen. It is important to note, of course, that he was alleged to have killed Allen, but that's not a problem because it was conceded the jury should know that anyway, and the judge summed it up. So my proposition is, at the very least, the jury should have known that the content of the statement of the 16th, the later concessions that it was untrue, and the fact that he was charged with killing Allen, and that would have been enough. The heads of my argument, for your note, is at paragraph 128 of my case at page 1485. The common law authorities on this were quite simple. The fundamental principle was that evidence as cross-examination as to credit had to be relevant. How was that established? Well, the locus classicus was in sweet escut, the well-known as they were when I came to the bar, dicta of Lawton, of Mr. Justice Lawton, that since the purpose of cross-examination as to credit is to show that the witness might not be believed on oath, the matters about which he's questioned must relate to his likely standing after cross-examination with the tribunal which is trying him or listening to his evidence. And that was applicable in civil and criminal cases to counsel on all sides. There were limitations on how far you could contradict the witness, and they're set out usefully in the case of Thunderbunk at page 1607 of the bundle. I needn't trouble you with them. That remained the law until 2003, when Section 101 of the Criminal Justice Act was enacted. The common law principle was very broad and was open, frankly, to abuse. And as I see it, looking back on this and thinking back to my early days at the bar in the 1970s and 80s at the criminal bar, the problem was that the criterion was easy to state, Mr. Justice Lawton's dictum, but there were no rules about cogency. How strong, how convincing did the material have to be before you could put it? And some barristers simply didn't bother about that. There were some members of the bar whose cross-examination was little more than a tissue of, how shall I put it, allegations, innuendos and insults. And lots of judges would put up with that sort of thing, perhaps because it was the sort of thing that they themselves had done when they were at the bar. This was, there was an old timer, I can't resist telling you. I'll tell you one anecdote, I promise, and it's this, that it's the maybe not apocryphal story of the old-time circuiteer who would rise to his feet, fix the hapless witness with a baleful gaze and say, "And who'll be the biggest liar in Middlesex when you're dead?" It wasn't quite my style, but it was some people's style. I think as the years wore on, things became better. Barristers and judges started to be properly trained, because very few of us had had any training for any job before we started to do it. And also ideas of being fair to the witness started to take root. But one can get an idea of the concerns that there were in the 1990s and 2000s, early 2000s, about abuses of the system, if one were to look either at the Runciman report or at the old report, and if of interest, I can give you the references. But suffice it to say that by 2003, there was sufficient concern that Parliament enacted the Criminal Justice Act, which required leave to be given for cross-examination as to credit unless there was agreement, and that could be done only if the evidence had substantial probative value relating to a matter in issue in the proceedings, or which is of substantial importance in the context of the case as a whole. Now, meanwhile, the case of Edwards had been decided in 1991. And that was a case which came about largely because of the misdeeds of a particular and by then notorious squad of officers, the West Midlands Serious Crime Squad, and I can go into that if it's of interest. And my submission about that is that that case has apparently been misread by the respondents. The case does two things. First of all, it sets out the ordinary rules that I have just set out, Sweet Escort and earlier cases dealing with cross-examinations to credit. But it then deals with particular problems that arose where, for example, you are trying to cross-examine a police officer because you're saying, well, Constable Buggins, you were disbelieved last time you gave evidence, or Constable Buggins, you're a colleague of Constable Smith in the same force, and he's got form for doing naughty things and fabricating notes and matters of that kind. And the Court of Appeal dealt very carefully with that second aspect, not because police officers are above the law, but simply because there are problems that arise in their case relating to misdeeds that only investigators can commit, and relating to the impact, for example, of disciplinary proceedings to which only police officers can be subject. And if your lordships wish me to, I can take you to that case in more detail. But in my submission, it does not affect and indeed reaffirms the principles in Sweet Escott which apply in the ordinary run of case and which apply, therefore, to a man like Lord Green. And the same applies to the case upon which my learned friend relies, the Privy Council case of Persad and Jayram. Although I should say that by the time Persad and Jayram was decided, which I think was in 2001, before the Criminal Justice Act, many judges were already applying the notion that there must be a solid basis for cross-examination as to credit, a point which is mentioned by their lordships in that case. In other words, the situation had probably changed quite a lot for the better compared to what it had been back in the 1970s. And so that, in short order, is my submission about why the cross-examination as to credit would have been proper in this case along the lines that I had indicated. The respondents, in arguing their case, faced two particular difficulties. First of all, that if I've understood it correctly, prosecuting counsel in all three trials effectively conceded the point that I've just made, that the limited cross-examination about the statement as the "I was kidnapped" statement would be proper. And I will simply give you the paragraph references to my case, which are paragraphs 60 and 62 relating to what Mr. Peterson said in the first trial, and paragraphs 75 and 79 relating to what counsel said in the second and third trials. They all said that cross-examination to bring out that he had lied to suggest that he had been kidnapped by Nigel Allen was relevant and proper. And indeed, the judges in both the second and third trials upheld that argument. And again, I didn't take your lordships to the detail, but I have set it out in my case. I do want to glance very briefly at the very curious anomaly, and one can't help feeling that...
Forgive me, Mr. Birnbaum, you said there were two difficulties. The second was...
Sorry?
You said there were two difficulties faced by the...
The first difficulty is the prosecuting counsel. The second is that the judges in trials 2 and 3 agreed that cross-examination as to credit was proper along the lines that I have suggested.
Thank you.
And they did so applying the more stringent regime of the Trinidad legislation, which is the equivalent of the 2003 Act. So even though they were applying a more stringent regime, they were still in favor of allowing the cross-examination as to credit along the lines that I submit was proper. May I say a word about the privilege against self-incrimination? The privilege, I probably hardly need to say this, but there was a lot of discussion about what questions counsel could ask. Of course, strictly speaking, the privilege does not forbid the asking of any questions. Theoretically, you can cross-examine until you're blue in the face, until the judge finally gets fed up and stops you. But sensible counsel have never done that, and they have always sought the guidance of judges. And I imagine they've done the same in civil cases as they've done in criminal cases of which I have had experience. The privilege simply allows the witness not to answer questions in certain circumstances. And if the judge decides that the privilege applies, then he has no discretion. The witness must be allowed not to answer the relevant questions. The judge must be careful to consider whether answering the questions will create any additional jeopardy for the witness. And it seemed to me, if I may say so, that the principles applicable to criminal cases are well summarized in Blackstone in the passage that your lordships have, the board has, at page 1532. And in particular, at paragraphs 30 and 31 of the case of Khan, which you have at page 1671. The cross-examination that I suggest should have been allowed could not possibly increase the risk of incrimination for an offence of murder with which Rodrigue was already charged. He could be asked about the statement of the 16th of December and about the 3 passages in later statements in which he'd admitted its untruth. The witness had protection in that the judge had made orders limiting publicity. And I summarize my criticisms of the judge at paragraphs 105 to 106 of my argument. The point is made by the respondents, oh well, the defense could have called evidence to contradict Rodrigue. They could have called police officers, for example, to prove that he had made those statements. So they could accept that the judge's ruling, and we do not have the actual ruling, of course, made it plain that the defense could not go into the content of statements at all. And calling any witness would mean going into that content, which was the area that he forbade. May I come, having paused for a moment to take a little breath, to, yes, please.
Was the judge actually invited to admit the whole of the contents of the first statement and the selected passages in the second statement that you're now suggesting to the board?
Yes. This is where the short answer is yes, but you have to look for it in Mrs. Elder's submissions. The problem about her submissions was, and this may be partly a function of the fact that she was not, that they didn't set aside time to do this. The problem is that she put it all together in one big lump. She said that she was entitled to cross-examine him about everything, if you recall. She said that she was entitled to cross-examine him about the "I was kidnapped" statement, and that being false. That she was entitled to cross-examine him about the fact that he had kidnapped and killed Alan. And she wanted, obviously, still also to cross-examine him about propensity. And I'm not going that far because I'm accepting that quite a lot of that would have been protected by the privilege. But you can find a number of passages, and if you want me to, I'll take you to them, where she was making it clear that, amongst other things, she wanted to cross-examine him to show that he had made a false allegation that he had been kidnapped. And indeed, it's perfectly plain that Mr. Peterson thought that she was entitled to do that, although he had reservations about the extent to which she could go into the contents of the statement. And the relevant passages are all set out in my case. My point is that the judge's obligation, having heard these submissions, was to sit back and to say to himself, right, I'm not going to allow Mrs. Elder or anybody else to say you're a murderer and you've murdered Nigel Allen. But what can I do properly to allow any of this cross-examination without imperiling the witness? And if he had done that in a proper and methodical way, he would have arrived at the answer that the other judges arrived at in trials 2 and 3. Well, I can at least allow cross-examination to show that he made the "I was kidnapped" allegation and that that was, on his own confession, false. And he could have guided counsel as to how they could do that. And as I've said, if this had all been thrashed out, it could actually have been opened by the prosecution, which would have made everybody's task a lot easier. I hope that deals sufficiently with my Lord's point. May I pass on to the question of miscarriage of justice, if that is convenient, and the question of the proviso. And it occurred to me that the board would find very useful the analysis of this sort of problem in the case of Benedetto at paragraphs 33 to 35, beginning at page 1534, which was a problem, not quite this problem, but the problem of the cell confession by the fellow villain, the man who's been occupying the cell with your client, as it were, and who claims that he confessed, and he's got a string of convictions as long as your arm, and he's got a motive to curry favor with the prosecution. And the emphasis in that case on the obligation of the judge to look at the case for himself and to ask himself, what are the weaknesses of this witness's evidence and his motives to lie, to which I need to draw the jury's attention. I begin by, well, I've just begun, my second point, having begun, is to say something about the peculiarity, as we would see it, of this indictment. Because
Mr. Birnbaum, forgive me, before you move to that, could you assist us in relation to the test which has to be applied in Trinidad and Tobago, so the proviso is concerned?
I suggest that the area that we're in is this area. Would the jury, if properly directed on all the relevant evidence, without doubt have convicted? And one can see that sort of approach in cases such as Pringle and Benedetto and Labrador, which are in your Lordship's bundle.
And where do we find that stated as the test in Trinidad and Tobago?
Ah, right. I see your point. In a Trinidad and Tobago case, I'm not sure that we do in those terms, but I would suggest that, yes. Thank you, Mr. Rowan. I'm about the assistance, I think.
We do. There is a case. Just turn it up.
Yes, it's coming up now.
In the bundle. Bear with me. Then. We are in.
Is it Brown?
Sorry, bear with me. Somewhere within my. Right, so it's Nigel Brown.
Yes, it is. Yes.
Tab 51565, and it's a paragraph 56 of that case.
Thank you very much.
Yes, thank you. Yes.
Mr. Birnbaum.
Yes, indeed. Thank you. Thank you very much indeed. The first point I wanted to make on the facts of this case relates to the indictment. The real case against these men was that they were the kidnappers. Two of them, Clarke and Martin, were alleged to have made admissions to the kidnapping of Sam Day, although in some respects those admissions conflicted with Rodriguez's account. The third, McGillivray, accepted through his counsel that he told police that he'd been asked to take part in the kidnapping, but had refused. There should, of course, have been a count of kidnapping on the indictment, but there could not be through no fault of the prosecuting authorities. It's possible that the jury got no further than finding that the defendants were guilty of kidnap and that they were convicted of manslaughter because the jury thought that they should not escape unpunished. And before somebody says that that is simply an unmerited speculation, I point out that it is difficult to understand the basis of the jury's reasoning. The judge made it perfectly plain, and this is the way that he chose to put it, that this was a joint enterprise case, and that the principal was Boodram, and that the jury ought to look at what Boodram had done to cause the death, and when they were considering state of mind of any secondary party, they should consider what Boodram had intended. Well, there was at least one member of the jury who wanted to acquit Boodram. We know that because the jury disagreed about him. And if anybody wanted to acquit Boodram, then that person should have acquitted these three men. It was clearly some kind of compromise verdict, and it may be that the jury had not fully understood the judge's directions, because it's difficult to see how one can reconcile the conviction of any secondary party, if anything at all, once Boodram is either acquitted or the jury have not agreed about it. So that is my first point. But then, really, my main concern here is the witness. He's described rather ironically, I thought, by my learned friend as a vulnerable witness. And the irony to me as a criminal lawyer is that in my neck of the legal woods, the vulnerable witness is the person who's the victim of a sexual assault, or someone who needs a screen, or is mentally challenged, or something like that. I would prefer to describe him as a very dangerous witness, who of course was vulnerable to being hanged. And the problem here is that there is a triple danger. First, I've mentioned that the defendants are not charged with the appropriate offence, and there is the temptation for the jury to convict them up, as it were, rather than to acquit them. The second is that he's the man who has the talent for detailed fabrication that the jury don't know about. And the third is, and this is really astonishing, that he gives evidence without the benefit of any immunity or undertaking. I probably don't need to spell out what I mean by those two terms, but just in case I do, by immunity I mean in general terms, a written promise from the prosecuting authority: we are not going to prosecute you for offence X. And I think here it would have to be both for the killing of Allen and for the kidnap and killing of Sandway. And by an undertaking, I mean, whatever you say about offence X or offence Y, we're not going to try to use it in your later trial. He didn't have those benefits at all. And it's easy to be hard on him. It's easy to say he was a terrible liar, but he was a terrible fix. For years, he lived with the knowledge that he was facing trial for the killing of Nigel Allen, that he might be hanged for that. And he must have been wondering on any of the many days that he gave evidence, what's going to happen to me and how do I answer this question in such a way that I don't put my own life in peril? And for that to happen in a case in any Commonwealth jurisdiction is really extraordinary, and it ought not to have happened. And so that is the first and perhaps principal reason why this should be regarded as an unsafe verdict, or as a case in which there has been a miscarriage of justice. The other reasons why I say that the verdict is unsafe are set out very briefly in my case, and I do just want to run through them so that your lordship, the board has the headlines in mind, as it were. And so may I just take you to page 1480, Injustice to the Appellants, at paragraph 111. Paragraphs 111, 112, I've just been traversed that ground. Paragraph 113 is the Benedetto point, the obligation of the judge to draw the attention of the jury to all matters that might justify the inference that the evidence was tainted, etc. In this case, I say the judge did the opposite. His ruling prevented the defense from exploring the most potent point that could be made against Rodrigue, that his own statement showed him to be a manipulative liar, determined to protect himself. And all there was an extremely short passage at our page 112 of a few lines. And indeed, paradoxically, although his ruling 115 allowed the defense to adduce the fact that Rodrigue had made a false allegation, which he then retracted, he never mentioned that fact in his summing up. Thirdly, the judge adopted what, in my experience, is a unique way of summing up. He repeated almost ad nauseam Rodrigue's account. Now, I know why he did this, because he thought it was fair and important that the jury should know the limits of what Rodrigue had to say in relation to each defendant. But it meant that it was Rodrigue, 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 Rodrigue. And the jury would have known it almost by heart by the time they got into their room. At paragraph 117, he appears to have given them what may well have been a written summary of what Rodrigue had to say, although I can't prove that because we haven't got that document. Fourth,
Mr. Bumble, do you have permission or leave to appeal in relation to the judge's summing up?
no, I don't. But I had made these points, if my recollection is correct, in my application. I think I had made the point that the judge, in relation to the matter, I can check if you like, in relation to the matter on which I have leave, I think I had made the point that the judge did not sum it up fairly and adequately anyway. Do you wish me to check that?
I'm proceeding on the basis, as far as I'm concerned, that the leave to appeal is in relation to cross-examination as to credit. But right. I wouldn't take you out of your way, please, because time is short.
Yes.
I'm
sorry, my lord.
I suppose you're now on miscarriage of justice, aren't you?
Yes.
So you've got to have got this far anyway.
Yes.
And at this point, you perhaps are entitled to say that nothing was redeemed, as it were, in terms of miscarriage of justice by the way the judge summed up the case.
Yes. I was about to make a similar point, but less succinctly. Thank you very much. Then I said, paragraph 118, that in a very vivid passage, Mr. Peterson was clearly a very good jury advocate, and indeed a very good advocate of the judge. He made very forcefully the point, well, look how detailed is the account given by Rodrigue. And that was a one-way street, because the defense were not able to adduce, in answer to that he was a man with a talent for detailed fabrication. Fifth, I deal with the fact that ultimately Rodrigue pleaded guilty. And your lordships can read that for yourselves. The main point, perhaps, is it would have been one thing if he'd simply said, I don't want to answer any questions about anything that I'm charged with. But he went further than that and actually said that he was innocent, which was a lie. And I say that his credibility is shot to pieces, and I give the detail of that at paragraph 120, including the very extraordinary point that if his story now is true, he was present within the course of only 3 weeks at 2 live burials. I don't think I need to go further into that. Sixthly, I argue that there were weaknesses in the case against each of the 3 appellants. In the case of Clarke and Martin, whom I accept had on the prosecution case admitted a part at least in conspiracy to kidnap, there were significant discrepancies with Rodrigue. And in the case of McGillivray, he never actually admitted the offence anyway. And we have a doc identification of him by this man, who, of course, if he didn't recognise McGillivray, or wasn't sure whether he recognised McGillivray, would have every motive to say that he did in order to curry favour with the prosecution. And I summarise all these points at my paragraph 128. Finally, may I mention two ancillary points, which I glance at only very briefly. The first is, and I'm frankly not sure what the answer is to this, because I don't have leave as to sentence, as my learned friend points out. The fact is, if this appeal is dismissed, these three men who were, if I may put it in this way, only the kidnappers, have ended up with 30 years, and everybody else, including Boudrum, got only 28. And it may be that your lordships would wish in those circumstances to remit the sentence aspect to the local court of appeal. The other thing is that,
before you move on from that, could the sentence in the case of the others have reflected the fact that they'd been through 3 trials?
well, I suppose so. I don't think, I have read the sentencing remarks briefly. I don't think the judge said that, but then these men had waited a very long time for their trial. But I take your point. But that, I would submit, would be a matter for the local court. The other thing I was going to mention would be that of course, in so many of these cases where the advice is to allow the appeal, the case is remitted to the local court for the question to be considered whether there should be a retrial. It may be that you would wish carefully to consider in this case, and perhaps to invite submissions from a learned friend as to whether there is any realistic prospect of a retrial in the extraordinary circumstances of this case. So, subject to any points that the board may have of me, and with thanks to my learned friend for drawing my attention to that authority, those are, my lord, yes. Please.
Thank you. Yes. Could you just help me as regards the evidence as between the 3, Clarke, Martin and McGillivray? Because my reading of it, and correct me if I'm wrong,
Yes.
is that one might say the other evidence in relation to McGillivray is significantly weaker than in relation to Clarke and Martin, given that they effectively confessed to being involved, should we say.
Yes, absolutely. And indeed, I did seek to indicate that. I'm conceding that if the police evidence was true, Clarke and Martin had at the very least admitted to conspiracy to kidnap. And indeed, one could say to the actual kidnap. But McGillivray hadn't, because he'd said, in effect, well, I was asked to take part in this, but I decided I didn't want to. And that is the distinction between him and the others. My learned friend has the point, to which I would seek to reply, if I may, if he makes the point, that he says that the conviction should be upheld anyway, at least in the case of Clarke and Martin. And if I may, I'd like to keep my ammunition, my powder dry on that, to see how he puts it. But I accept my lord is quite right. McGillivray has not admitted the offence of kidnapping, whereas if the police evidence is correct, it would seem that the others have, or at least have admitted, conspiracy.
A second question, if I may. Is it open to us? I mean, have you permission to ask us to look at the sentences?
That's the very point that I raised. I'm not sure whether I don't have permission to do that, but I'm inviting my lords to consider it as a matter of justice. That's the highest I can put it. because it does seem to me, at least, to be an anomaly and potentially an injustice if the convictions, sorry, are upheld.
And my third and last question, sorry to bombard you all at once.
No bombardment at all.
The actual terms of the proviso, I think you've indicated that we're going to get the precise terms from the Brown case,
Yes.
insofar as that applies in Trinidad and Tobago. I'm just at this moment marginally unclear whether the test involves the words significant miscarriage of justice.
Yes. I have always found the term significant in that phrase rather difficult. If I may say so, I've always wondered what was the difference between a miscarriage of justice and a significant miscarriage of justice, rather like being a little bit pregnant. And I did actually look in about 2012 for another case. I looked at a whole range of cases to see how the board in various other cases have expressed the test. And sometimes I found significant miscarriage of justice. Sometimes I found miscarriage of justice. Sometimes I found unsafe. Yes, my lord.
The language of the statute, which is quoted in the case you referred us to, actually makes the same problem, but the word is no substantial miscarriage of justice.
Yes. Well, again, substantial may carry the same problem. I mean, I think from a practical point of view, that one can often see that the Privy Council, like the Court of Appeal, says, well, yes, this is a very good legal point. Counsel is absolutely right. And indeed, there are even better arguments than those that he's made in his favour, which he's missed. But actually, what does it matter? What difference would it have made? What difference might it have made in the real world with this jury who'd heard the evidence that they had and heard the summing up that they heard? And my submissions are directed, if you like, to the what difference might it have made. And if you think that it might have made a difference, then you ought to allow this appeal for all three appellants. If you think, well, no, interesting, may be right, but wouldn't have made a difference at all, then that is the end of the appeal on a practical level in my submission. And words about substantial and significant maybe do not assist one very much in this area. So unless there are further matters I can assist on, those are my submissions. Thank you.
Don't think there are any further questions. Thank you. Thank you, Mr. Birnbaum. Mr. Pennington-Benton.
Thank you very much, my lord. Can I just do a sound check, as it were?
Yes, we can hear you loud and clear.
Lovely, thank you very much. I thought I might, if it coincides with your lordship's feelings, just open my case with an outline, and then perhaps we can have that 2 or 3 minute comfort break. I just starting where Learned Queen's Counsel left off. I think I agree basically that serious, substantial, or some other preceding word before miscarriage of justice doesn't bring much to the party. My case will be essentially that I will be relying on the made no difference submission effectively. But can I just outline my case? So this is a case, my lords, as you will have, my lady, as you will have seen, which focuses on a restraint placed on the cross-examination of a state witness. In order to succeed in this appeal, the appellants have to persuade the board that had they been allowed to cross-examine Nigel Roderick, I'm sorry if that's not how you pronounce it, but I'm afraid that's what I've been used to saying, so I'll stick with it if I may. If the appellants had been allowed to cross-examine Nigel Roderick further, and in the ways now proposed, it would have made a real difference to the outcome. in my submission, for essentially the 6 points set out in my case, I say that in the end it would have made no difference. And can I just explain in overarching terms how I set out my case? So the first point I make is in relation to the discretion vested in the trial judge to control the questions put to a witness. And there's a difference there between myself and Mr. Birnbaum about the true nature and scope of that discretion. But I say, first of all, the judge's decision was within the bounds of his discretion and therefore not wrong. But even if I'm wrong about that, and in fact, in any event, one needs to go on and consider whether the restriction placed on the cross-examination caused a miscarriage of justice. Because, of course, I would accept that even if the judge's decision was within the bounds of his discretion, if the effect of it was to cause a miscarriage of justice, then Mr. Birnbaum's clients have a case. So that's when I come to points 2, 3, 4, yes. Lady Rose.
Well, I didn't quite understand that, because you started that sentence by saying, if I'm wrong about whether the ruling was within his discretion, then you need to go on to consider whether it caused a miscarriage of justice. But at the end of your sentence, you seem to be saying you accept that even if it was a ruling within his discretion, if it led to a miscarriage of justice, then they have a case, whatever
Yes.
What that means. So I'm not quite clear now as to what you say the relationship is between the two parts of the case. Was the ruling within his discretion, and has there been a miscarriage of justice? If you could either now or after the break just clarify that for me.
Yes. Yes, I think I've come to the realization as I've been preparing for this that either way, whether the judge's decision was within the bounds of his discretion or not, I have to go on and answer the question as to whether the effect of that ruling, even if it was within the bounds of his discretion, has caused a miscarriage of justice. In other words, point 1 really, in a sense, is something of a sideshow, because in any event, I have to look at the effects of the judge's ruling. So I accept in any event, I have to face the questions about the miscarriage of justice, whether his ruling has caused a miscarriage of justice in this case. Even if it was a ruling that was on the authorities open to him, if it's one that caused an injustice, he ought not to have made it. That's the point. So that then leaves me.
Maybe he doesn't have a discretion to do anything which would result in a miscarriage of justice.
Yes, well, there's different ways of putting the same point. Yes, but what I'm really saying is I need to focus effectively on points 2, 3, 4, and 5, because they're the ones that really matter.
And these are the points set out in your written case at page, remind me where it starts. It's the second part of it.
Yes.
Mr. Paddington Benton, could I just ask a question about that?
Yes.
It sounds, from the way that you're putting it, and I don't want to put words into your mouth, but it sounds as if you're effectively conceding that there has been, should I say, a misdirection by the judge, and you're really focusing all your fire on whether the proviso applies. Is that right?
It is, respectfully, my lord, it's not quite right. I say that the judge's decision was within the bounds of his discretion, and actually it caused no miscarriage of justice. But if your lordships find that it did cause a miscarriage of justice, then working backwards, it would follow that his decision was wrong, if that makes sense. But your lordship's right. I do focus on the effect of his decision.
I find it hard conceptually, maybe it doesn't matter. I find it hard conceptually to see, though, how if the judge has given a proper ruling as to what evidence can or can't be allowed, it could be said that there was a miscarriage of justice.
Well, it may be that it is a I suppose the point is that the judge at the time, faced with the case that he was faced with, being asked to make the ruling on the basis that he was, made a decision that was perfectly, on my submission, justifiable, but it may have had unintended consequences that have led to a miscarriage. I say that it didn't have those unintended consequences, but he couldn't have predicted all of the consequences that flowed. I think that's my point. And of course, the more nuanced way in which the case is now put, i.e. you could have allowed judge cross-examination on the first statement to do with the kidnapping and 3 short passages in the second statement. That's not the case that was put to the judge. So again, effectively what the appellants are saying is, well, look, what the judge should have gone on and done is to consider an alternative case, an alternative way of putting the application that was never put to the judge at the time. And I say, well, look, I mean, I think that's a little unfair on the judge. But at the same time, if the result of all of this is that the fact of the matter is, no matter whose fault it was, and even if the judge's decision on the face of it was all right, the fact of the matter is probative evidence was kept out, then obviously it's not like a civil case where you can say, well, look, tough, the judge was the judge was within the bounds of his discretion, that's the end of it. You have to take a results-based approach, because ultimately we can't keep people banged up if there's been a miscarriage of justice, which there hasn't been. Does that make sense?
Way of analysing that would be to say that the judge had an obligation to keep his initial ruling under review as the case progressed, so that if it materialised subsequently that there was a miscarriage of justice, that he should then have revised it.
Potentially, if something came up during the trial, but I don't think this is that sort of case, because obviously many of these events that have happened since have happened later. Now, point 6 of my reasons, as it were, really is a separate standalone point, saying that the decision made by Mr. Justice Holdit later under a different statutory regime just doesn't take the matter one way or the other. So what I'm really left with is points 2, 3, 4, and 5. And just
Could I have the page number, please, Mr.
Yes.
It's 1500. The submission starts at point 1 at 1500.
Yes, and then they go on. Yeah.
Okay.
I just want to explain a little bit more about, certainly in response to a point raised in respect of causation, quite rightly by my opponent. I just want to explain how these points fit together. So point 2 is, I say that the practical implications, the practical effect of the judge's ruling was limited in circumstances where Nigel Roderick was standing by the fact that he'd made the first statement, i.e. the one about the detailed kidnapping of himself, and was denying making the second and third statements. So, in other words, in short, and it was always been Mrs. Elder's case right from the beginning during her cross-examination and when she was on her feet responding to the judge's intervention, it was her case from the very beginning that she was never going to go to voluntariness. So she was never going to be calling the officers and proving, contrary to what Nigel Roderick was saying, that these statements were voluntarily given. Never going to do that. And my short point here is that how much further would it have got the defence to have said, oh, well, look, in your second statement, you admit at this point and at this point that your first statement was false, to which Nigel Roderick would say what he'd said about 20 times in the evidence already. Well, I didn't make the second statement. So how does it help? That's the short point there. I'm obviously going to expand upon that in my more detailed submissions, but I say effectively the restrictions would have really made no difference when one looks at them in context. That's also point 4, although point 4 makes a slightly, I'm going to deal with points 2 and 4 together, and then 3 and 5 together. They should have really been in that order, but point 4 says, well, look, the relevance of Nigel Roderick's ability to invent detailed lies, namely a detailed account of his own kidnapping, which he subsequently admits to being false, that's only a powerful point in cross-examination if Nigel Roderick admits the first statement isn't true, but he doesn't. So again, where actually would the line of cross-examination, if permitted, have taken the appellants? My primary submission is nowhere. And that, if I win on points 2 and 4 taken together, the effect is that all of the convictions are safe, because I basically say it would have made no difference, and therefore their convictions should be upheld. If your lordships are against me on points 2 and 4, and your ladyship, says, look, it's bound to have made some difference, the jury are going to have had real concerns about Nigel Roderick's evidence. My alternative position in points 3 and 5 is to say, well, there is a core irreducible minimum of his evidence that would have been accepted by the jury, and that is the date of and the basic circumstances of the beating up of Mrs. Rampersad in the field on the 27th of November, because that part of Nigel Roderick's evidence was supported, A, by the fact he could take the police to the site of the burial, and B, the medical evidence. So no matter how useless the jury might have thought that Nigel Roderick's evidence was, that part of his evidence was always going to be accepted. It is obvious he was there. It is obvious he saw the woman arrive and be beaten up. It is also equally obvious in my submission that the jury would have accepted the admissions of Clarke and Martin. So if I get to points 3 and 5, I accept McGilvery's out, because as my Lord Burrows said, the evidence in respect of McGilvery depended 100% effectively on Nigel Roderick. And if I don't persuade your lordships and ladyship on points 2 and 4, then McGilvery's out. So 3 and 5 applies only to Clarke and Martin. And I say that their admissions, and we can go to the content of their admissions as summarised by the judge, together with that core irreducible part of Nigel Roderick's evidence that would be bound to have been accepted, makes out a case in manslaughter. Now, it's said against me, well, look, these findings by the jury, these decisions in respect of the appellants as against the other defendants are hard to explain. My submission, they're not. The only 3 people who were convicted were the only 3 people who gave confessions or made statements to the police. McGilvery's was, I was around, but actually, you know, I was driving in a car, but I had nothing to do with it. Well, obviously the jury. So in other words, the jury only convicted those 3 persons who made statements to the police. And they convicted those persons of manslaughter, plainly on the basis of what Nigel Roderick had said happened in the field, but without accepting Nigel Roderick's evidence about the particular attribution of any person's part to what happened in the field. Because, of course, if the jury had accepted Roderick's evidence about who did what in the field, then all of the defendants would have gone down. So it's already the case that the jury must have not been willing to accept everything Nigel Roderick said about who did what. In my respectful submission, it's quite obvious what's happened here is the jury has accepted the admissions and accepted the fact that the woman was beaten up in a field after she was passed to them by the kidnappers. That's a case of manslaughter. And it remains a case of manslaughter, no matter how much cross-examination there is of Nigel Roderick about his statements. Would that be a convenient point just to take 5 minutes or 3 minutes?
Yes,
We're allowed.
Benton, we'll take 5 minutes. It's fine. Thank you
Thank
very
you.
much. Mr. Pennington Benton.
Thank you, members of the board. Can I, with the introduction I gave before the break, just very briefly deal with point 1, because as I say, I think I need to press on nonetheless and simply give your lordships the gist of what I say and some references. I would invite your lordships just to consider the case of Passad and Jerame. It's at volume 5, 1698, and I rely on paragraphs 14 to 16, and draw from that the proposition that a charge in respect of which there has been no trial is generally not a proper basis for cross-examination, but importantly the reasons for concern about allowing cross-examination on misconduct that hasn't necessarily been proven are set out in paragraph 16 of that same judgment, and they refer to questions of policy, namely collateral issues, but also fairness to witnesses. But I immediately accept, of course, that this case is different because you don't just have a mere charge, you have two statements on the 20th and 21st of December 2005 in which Nigel Roderick admits involvement in the killing of Alan. And those statements were witnessed by various different people. So there is, to use the language of Passad, a solid basis for cross-examination. And I accept that that's an appropriate test. But what I say is that the discretion of a trial judge cannot simply end abruptly at that point. It can't simply be said, oh, well, if the evidence creates a solid basis for cross-examination, you must be allowed wholesale to ask whatever questions you want on it. The trial judge must have a overarching discretion, to which I refer your lordships again to paragraph 14 of Passad, to have regard to appropriate restrictions on questioning when the fairness of the proceedings and the persons involved in the proceedings so require. And in this particular case, the judge, it is plain, although we don't have the reasons for the judge's decision, it is plain from the argument that the judge had in mind three related concerns. The first concern was a risk of collateral issues derailing the trial. Keeping a lid on things, in other words. So if counsel were allowed to cross-examine on the contents of all of these statements, and that would go into questions of voluntariness, for example, because Nigel Roderick said, well, I didn't make the last two statements, the police made them and I just signed them to get out of the station. And you risk basically having a trial within a trial on the Allen murder. That's a perfectly proper and understandable concern. The second concern the judge had was a risk of self-incrimination on the part of Roderick. You will have seen that Roderick already got himself in trouble, as it were, in the preliminary inquiry by admitting certain things that he was incriminated, for example, in the Allen matter, and then tried to row back from that during cross-examination by Mrs. Elder in this case. So that's already an example of the sorts of problems that can arise. Another difficulty that the judge had in mind was Nigel Roderick restricting the scope of his defence in later proceedings. So there's quite a long exchange between the judge and counsel about, well, look what happens if Nigel Roderick actually later, as people often do in Trinidad, and the judge saying that, not me, says, look, we always get these admission statements and we're always throwing them out. Because somebody says, well, actually, you know, I was promised this, I was promised that, blah, blah, blah. Obviously, as the prosecution, that's not my case. My case is these statements were good to go. But the point is, and the judge recognised that Nigel Roderick had to be given the space to make all of those points and to seek advice on all of those points, and if necessary, run all of those points in his later trial. And you cannot allow someone to be cross-examined on the detail of all of these statements in circumstances where he's likely to tie himself up in knots and restrict that later ability. So those are the three concerns that the judge had. I'm just going to give your lordships the references. I'm afraid the first one's rather long. It just says volume 1, tab 14, page 190, 190 being the electronic number, to 208. I say if your lordships read those pages, your lordships will see those three aspects, those three concerns quite clearly. Also, please, I would ask your lordships to read in the same tab pages 217 and 218, 226, 239 and 248. I would also ask your lordships to consider the way in which the application was put by Mrs. Elder. I accept, as my friend rightly says, on her feet, and she did a good job of it, but her case was put very clearly. I want to prove that these admissions are true, i.e. Nigel Roderick is a murderer, or he's guilty of homicide, and he's admitted as such. So that was the way the application was put to the judge. I'll just give your lordships two references in my case at paragraph 50 and paragraphs 20 and 21. So there is a certain point there about a judge dealing with the application as it's put to him, as opposed to the application that's been dreamt up on more nuanced terms several, 10 years later. But that's the way it was put at the time. That's all I say about point one, because I need to get on to deal with the effect of the judge's ruling. So my primary position is the judge was entitled to make the ruling he did, and he gave perfectly decent reasons for making it. But in any event, I say, dealing at points 2 and points 4, it would have made no real difference had they been allowed to cross-examine in more detail. Now,
I'm sorry, before moving on from point 1, did the prosecution have no objections to the details of the first statement being put in evidence? If they did object to the details, is that something which you can stand over now?
The prosecution did not concede that the details of either statement should be gone into. The fact that the first statement dealt with a kidnapping, that was said by Mr. Peterson for the Crown, that for the state, sorry, could be gone into. I might just have to come up with, I was trying to find the references, but what he then says, but he certainly objects to the detail of either statement. Line by line is the phrase that he uses, and he said he objects to that. It culminates, I think the best reference is probably in respect of the charge at page 242, line 43 onwards. He says,
bear with us just one moment, if you would, Mr. Pennington. 242.
242, tab 15.
Yes.
So what he says in respect of the charge, which is the second and third statement, he says, it will be open to your lordship effectively to allow cross-examination. I don't want to paraphrase. It says, in the exercise of your lordship's discretion, your lordship could even permit as to when the charge was laid, who was the victim, that there was a committal, when was the committal, and all those other facts and circumstances surrounding the pending charge. And then in respect And in respect of the first statement, he also says, well, you could say that it's about a kidnapping.
Where do we see that?
But you can't, yes, just find the right. Sorry, I'm just, while I'm on the second and third statements, can I also just give your lordships a reference at page 190, line 31? I'm objecting to Mrs. Elder going into the detail of that. It's a charge, not a conviction. And then in respect of the first statement, I'm going to have to come back to it, I'm afraid. Sorry.
Was there?
Hang on. No. Basically, he says, I don't object in principle to going into the point, and then Mrs. Elder says later in the transcript, I'll have to find the passage, well, Mr. Peterson doesn't object effectively, so why do you? And then Mr. Peterson says, well, I don't mind going into it, but not line by line. And actually, that's not that dissimilar to what the sorts of submissions that were being made later before Holdip and before Jack. I mean, it's a case of how far you go into the statement. That's really the issue here. But in any event, the judge's view was that you can't go into it at all. So the jury...
Well, in due course, Mr. Pennington, we're going to need that reference to Mr. Peterson. Not now, but at some point.
Yes. Yes. But in any... Sorry.
Was there any risk of self-incrimination if the judge had permitted cross-examination as to the detail of the first statement?
Only in as much as the detail of the cross-examination would have been, but later you said something different. Because the only...
Would there be any risk of incrimination if the detail subsequently was restricted in the way that's now being suggested?
Sorry, I'm not sure I follow the question. I mean, the questioning would be, because it's not just putting these statements to evidence, it's a case of allowing questions to be asked on them. And of course, the prejudice, yes, is about, because of course, the only questions that are going to be asked of the first statement are, well, look at all these things you said, and then later you said that they're not true. To which he's going to then have to be answering, well, actually, what I said in my second statement was this, what I meant was this. And that's what the judge was concerned about, because yes, the risk then is, as an unrepresented person without legal advice, he starts tying himself up in knots in a way that will almost certainly be relied on later. So the answer to your lordship's question is, if the judge simply read out the contents of the first statement, that's fine, but that's not what is going to happen. What is going to happen is there's going to be line by line cross-examination on the differences between the first statement and the second statement, for which the witness is going to be very much feel obliged to kind of explain. And that's when you end up getting into a very complex and confusing state of affairs for the jury, and into all sorts of issues that potentially will limit Nigel's defence in the trial of the Allen matter later. And that's what the judge was concerned about.
Well, he was likely to say, wasn't he, Mr. Pennington Benton, as he did in fact say to Mrs. Elder's questions, that the second and third statements were not voluntarily made.
Well,
And that would be
yes.
the end of it.
Well, it could be the end of it. There was a risk he would say more, and that was what the judge was concerned about. Certainly at the preliminary inquiry, he did say more, didn't he? He said, for example, "Oh, I'm incriminated in the second statement," to which Mrs. Elder said, "Yes, you are. They're damning, aren't they?" To which he said, well, what I meant was, I mean, it's just a nightmare, basically. Once you start going into the detail of them, it's a nightmare. But, of course, that's the risk that the judge had in mind. But as it played out, your lordship may well be right, because, of course, your lordship is suggesting the evidence play out in the way that I say it may well have done, which is actually he just denied it all, which is why I say, in fact, allowing the defence to go into the contents of the statement wouldn't have actually got them anywhere.
Well, that's a different point. My lady, Lady Rose has a question, then Lord Legate.
Yes, I think the page you were looking at was perhaps 219 to 220, where there's a discussion about going line by line. But before we get to that, can I just be clear on my own mind? Is your concern, or is your submission, that one of the judge's concerns was that it could not be known what stance Mr. Roderick would take in the Allen trial as to whether the 16th of December statement with the story of the kidnapping was true, or whether in fact it was not true, as he had supposedly said in the statements of the 20th and the 21st, and that the judge's concern was not to prejudice, in a way, whatever decision Mr. Roderick decided to make when in the Allen trial as to which of those versions he was going to put forward in that trial. Is that broadly the submission you're making?
That's correct. That's exactly the conversation that the judge is having with counsel, saying, well, hang on a second, what if he later says, I made those statements, but they forced me, or, I didn't make the statements. And of course, when he gives his evidence, that is precisely what Nigel Roderick does. My Lord Legate.
I recognise that it may well be that the judge's ruling was necessary to protect the fairness of Mr. Rodriguez's position. But if that resulted in an unfair trial for these defendants, then that's no answer, is it? I mean, this extraordinary situation might be one in which it was simply impossible to have fairness on both sides. But that isn't mean that these defendants had to make do with an unfair process.
My Lord, I agree 100%. And that's why I say that point one, interesting though it is, I don't want to spend too long on it, because that's the conclusion that I came to myself as well. There's not much point in me trying to persuade you that the judge had an incredibly difficult decision to make, and he made a decision that was in the bounds of his discretion and is understandable and explicable and fair, all of which is true in circumstances where, unless I can persuade your lordship that actually, substantively, they weren't prejudiced. And that's where I say come in grounds points 2 and 4. I don't know why I didn't do them in order, I'm sorry. But let's basically, point, yes, my lord, there's Lord Stevens.
Well, it was, of course, the prosecution that caused this difficulty. Nowadays, the assisting offenders would be dealt with under the relevant legislation, and they would be prosecuted and convicted, or the agreements would be entered into with them before they gave evidence. So everyone knew what was occurring. Well, why didn't the prosecution do that in this case? Well, why did it take so long to prosecute the Allen murder?
My lord, I don't have instructions on that. That is, of course, a contextual point that my learned friend makes, and it's a fair one. But it's not one that is a freestanding ground appeal. I mean, like, I'm afraid after doing these Privy Council cases for 10 years, I'm a bit lost to how to explain delays in all sorts of areas of process. But I mean, the simple fact of the matter is that is certainly something that Mr. Birnbaum will rely on in terms of saying, well, look, the overall context wasn't great, but we are where we are. We had these very serious offences that were required to be charged and dealt with, and they were being dealt with. And the question is whether further questioning on these lines of inquiry would have made any difference. In my submission, they wouldn't. But yes, I can't get away from the fact that in an ideal world, what should have been, you should have tried Nigel Roderick first and then dealt with this matter, of course. So, right, where do I start? So,
not necessarily now, but you say in your paragraph 68 that there were other independent witnesses to the kidnapping. It would help me if you could just let us know, apart from the admissions by Clarke and Martin and the evidence of Mr. Roderick, was there any other evidence about the involvement of all three appellants in the kidnapping by the witnesses to the kidnapping?
there is no, well, first of all, Clarke himself didn't take part, as far as we know, in the actual kidnapping. He was playing lookout and he supplied the guns. Martin and McGilvery, there's no independent evidence of either Martin or McGilvery taking part in the kidnapping itself. So the only evidence, the eyewitness evidence of the kidnapping, is just about a car pulling up, two people getting out, there were two guns, the woman being bundled into a car and being driven off with her legs hanging out of the door. No one was able to identify any of the actual defendants. So the case, yes, so it's just to the circumstances, the fact that this was a violent kidnapping. I mean, insofar as it needs to be shown, it's very clear that this was a violent kidnapping involving guns, and that the woman was physically bundled into a car and driven off. So the
violent kidnapping gets you home on manslaughter.
Yes, I say so because the kidnapping was still plainly ongoing,
yeah,
and the victim was killed during the course of that same kidnapping, even though the three appellants had played their part. Can I just quickly? I'm sorry. How long do I have until past? Is it or something? Sorry.
Oh, you originally were allocated until 10 minutes to 1, and then we were going to have a short reply. But
okay, well, I'll try and do it.
In
Yes.
fact, Mr. Birnbaum finished very early, so he should be allowed some time to respond to you.
And he's bought himself time to respond to my manslaughter argument, which is fair enough. So I'll try and finish in good time. Okay, fair enough. So can I just ask your worships to turn up, please? Tab 17 in bundle 1, page 266, please. So this is the cross-examination of Nigel Roderick by Mrs. Elder. She's representing Boodram, the boss, alleged boss of the. So first of all, Mrs. Elder cross-examines. This is on page 266. at line 36 about the statement on the 16th of December. So this is the first statement. This is the statement about kidnapping, Nigel's own alleged kidnapping. And he says, yes, ma'am, yes, ma'am. That's the statement. He basically accepts that statement. It was taken down in writing over on the next page on 267. I signed it and so on. And then on page 267 at line 40, he says, and this statement you gave to the police on the 16th of December, you subsequently admitted that you had lied to the police. No, ma'am, I did not admit that I had lied to the police, ma'am. I did not admit. No. Remember, you told me you signed on the 21st of December. You didn't tell a justice of the peace that the statement you gave was not correct. On the 16th was not correct. Ma'am, I did not tell no justice of the peace. And then at page, line 15 on page 268, I was made to sign. So this is the statement of the 21st of December. He said I was made to sign. And then at line 43 on the same page, this is not my writing, ma'am. You see your signature. I'm seeing my signature. And then on the next page at 269, at line 12, Mrs. Elder reads the certification to the witness, refers to the fact that his wife, Denise Phillip, had signed it, accepts that that's his wife at line 40. On the next page at 270, line 6, I will not accept that, ma'am, because I was made to sign these documents. And then at line 21 to 23, she, my wife, was also signing the documents. Who made her sign it? The police. And he basically takes the same tact in respect of the 20th of December 2005 statement. I don't necessarily need you to turn up the references, but what he basically says on 273 at line 12 in respect of the 20th of December statement, he says, yeah, sign and go home. So I sign. They say sign and go home. Yeah, so I signing to go home. And the contents of the statement of the 20th, you never told the police. No, ma'am. Effectively saying, look, the contents of the statements were made up or drafted for me. I signed them because I wanted to go home. And then later he says, effectively that he was told he would be a witness. And that is on page 292 at lines 42 and following. I believed I was going to be a witness, so I spilled my conscience and my guts. That's the question put to him of what he told the magistrate at the preliminary inquiry. He keeps saying this line over and over again, my lords. You would have seen, well, it was the way they put the questions, Not very convincing, but anyway, that's what he said. And then he accepts, again, as he has done in a number of places at page 293 of the transcript, if it is there, I said it. It is there, I'm not denying it. And then he, yes, so basically saying he was told, look, you'll be a witness, so you may as well tell us everything that's happening, and then he gets charged. That's basically what he's saying has happened. So, in those circumstances,
he's to be a witness sorry, he's saying he's going to be a witness in the Allen trial or in the Rampersad trial?
In the Allen matter. Yes, in the Allen matter. So in other words, he says, well, look, that's what Mr. Peterson for the prosecution, I think, refers to in the exchanges with the judge during the debate about whether or not the cross-examination should be allowed on these witnesses. He says, well, this is what he refers to as his case of being fooled up. In other words, he was saying, well, look, I was basically tricked into signing all this stuff on the basis that I'd be a witness. Then I was charged with murder. and now basically I want to go back on it all. That's his basic argument, and what the trial judge is saying in the Rampersad matter is, well, shouldn't he be allowed to make that case in the other trial? In any event, that's going back to point one, sticking with and the reference, by the way, for fooled up, etc. If your lordship says at 249 lines 5 onwards, Mr. Peterson explains what he thinks Nigel Roderick's case will be in the Allen matter that needs to be preserved effectively. So just pausing here, what I say in respect of relevance, what's my keyboard, is the detail of the first statement, the detailed kidnapping, was not really going to help anybody because, sorry, not help the appellants, because Nigel Roderick would simply have said, well, yes, that's true. So in other words, there's no forensic value in saying to the witness, well, look at this really detailed account you've given, and you later admitted it's false. We said, well, don't admit it's false. Yes, my lord.
That doesn't really follow, does it? Because the jury wouldn't have to accept that the first statement was true. They could take account of the fact that he had subsequently made contrary statements and other evidence, and they might have thought, well, we can't be sure one way or another about this, but on one view of things, he is the most intricate liar that you could possibly come across.
Well, yes.
Or when his credibility is shot in an opposite direction.
Well, my point really is that there's no evidence to contradict Nigel Roderick's statement that the later statements had nothing to do with him. I mean, I accept there's the signature of the witnesses and all the rest of it, but in circumstances where you're not going to call the officers, what basis could the jury have for doing anything other than saying, well, look, there are two inconsistent statements. One he stands by, the other he says, well, look, you know, I didn't have anything to do with that. And there is zero evidence before the court, because no one's called the officers, to rebut that. In those circumstances, the jury can't, if there's no evidence, positive evidence, the jury can't actually really do anything other, can they, than accept. But of course, Miss Eldon could say these statements are inconsistent. She did make that point. I mean, she was allowed to make that point. But how does it, what does it add really to say, well, look, here's a very detailed statement you made, but it's all wrong? No, it isn't. It's all true. I told you it's true. And you're just at the same position, aren't you? If I'm wrong about it, yes.
Well, that leaves the arbiter as to whether it's true or false to Mr. Roderick, whereas I rather imagine it should be the jury that makes that decision.
Well, it is the jury, but in circumstances, the appellant's case is based on an argument that, look, if we'd have been allowed to cross-examine into the contents of these statements, it would have made all the difference. And what I'm saying is, well, is that right in circumstances where the witness denies making the later statements and no evidence has been produced to doubt him on that point? So how does it help by going into the detail of a statement? Why does that make all the difference? In my respectful submission, it doesn't. It makes no difference.
Was the, just a point of detail, at page 1455 of the bundle, we have the certificate at the end of the 21st December statement, in which Mr. Roderick confessed that the earlier statement wasn't correct. Was
Yes.
that actually put in evidence, that confession?
No.
Well,
I mean,
why not? Why not?
Well, Mrs. Elder, as I think I've just said, did during the questioning take him to the certificates. I mean, it was. Before I say no, I think I just need to actually turn up where I was, because
She did. She did ask
depending
about
on
that.
when you say in evidence, I mean at 269 she said, she read out, I certify that I spoke to Nigel Roderick, blah 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 blah. Nigel Roderick confessed that this statement was not correct and that he's prepared to change the statement.
Yeah. Okay.
So is that what?
Yes. Yeah.
But it wasn't, you know, put the jury weren't given the statements, but it was open to Mrs. Elder, and she did in many times say, well, look, this is all nonsense. You're saying that a justice of the peace is lying, you're saying a wife is lying, you're saying the police is lying, this is all nonsense. You're obviously just trying to curry favour with the prosecution, you're trying to get out of jail free with the Allen matter, and that's why you're lying on my client. I mean, these points were made ad nauseum by Mrs. Elder, and as I've said, I've given references in my case. In fact, moving on to the second and third statements, in fact, Mrs. Elder did get out many details about the Allen murder.
Before you go on to that, can I just be clear that what was happening actually in court was that Mr. Roderick had in the witness box and was being shown these statements, the 16th, the 20th and the 21st, but the jury never saw them.
Correct.
They only saw him looking at them.
Correct. Yes. Correct. So and then Nigel Roderick was taken to his deposition evidence in the Rampasad matter, where he'd admitted that the statements, i.e. the statements of the 20 and 21st of December, incriminated him. So all of those points were made, and I've given references in my case to a whole series of facts about the Allen murder that were in fact drawn to the jury's attention. Because so that's really dealing with the kidnapping detail. I say, well, that would have made no difference. But then when you talk about the contents of the second and third statements, obviously there's a serious danger of self-incrimination, because this is where Allen is basically describing the part he played in the car that was travelling in which Allen was killed. And but as I understand Mr. Birnbaum's case today, he says, well, I would have only gone into 3 very short passages in the second and third statements where the witness admitted that his earlier kidnapping story was false. So again, I'm not really sure how much further that would really have taken matters. But just for the record, of paragraph 30, yes, my lord.
Can you just tell me exactly what exactly did the jury know about the content of the first statement?
Well, through Mrs. Elder's cross-examination, they got to know almost very little about it.
Did they know the story?
I don't think they did, but as Mr. Birnbaum says in his case, I'll have to turn up the reference to it.
Well, did they have any idea of what anything it might have said, or just that it was a statement in the abstract, which was contradictory to the later ones? Is that all they knew? That,
yes. Although later on in the cross-examination, as my learned friend points out, another of counsel was allowed to go into it in more detail when he shouldn't have done. So in actual fact, they did get to know more about the detail of the first statement. But Mr. Birnbaum says, well, actually, that was prejudicial because it gave the impression that it was true.
But was that related in terms to the first statement?
Was what?
It's certainly the case that Mr. Rodriguez was able to give evidence that he had been kidnapped. But was that related in the course of his evidence to the first statement?
I would have to, I believe so. I have to look at my learned friend's case, because he sets all that out in his case.
I did not understand that it gave any indication as to the contents of the first statement.
Right. Certainly the judges, I would have to look it up, but certainly the judge's ruling was you can't go into even what the first statement was about. Mr. Birnbaum's going to help, I hope.
Yes, Mr. Birnbaum.
If you just look, please, at paragraphs 70 to 74 of my case, which begins at page 1466, you'll see it all set out. And if I may say so, the context of this was that one counsel wanted to make a point about what had happened on the 15th of December. It was McGilvry's counsel, in fact, where at one stage, Rodrigue had said, well, I saw McGilvry on that day. And counsel's point was, well, you couldn't have seen him on that day if, in fact, you'd been kidnapped, which is what you told the police. And we got to the extraordinary situation where the judge allowed McGilvry's counsel to bring out the fact, inverted commas, I have been kidnapped, when the jury were not being told that he had then admitted that was untrue. So
Yes,
that,
well, I understand that, Mr. Birnbaum. My question is rather that when Mr. Sinclair Douglas asked these questions, which elicited the answer
yes,
that he had been kidnapped, whether there was anything that would have caused the jury to link that with the contents of Statement 1.
Yes, thank you. I'll look into that. Thank you. I'll go back to the transcript.
Thank you.
Thank you. I'm sorry I wasn't able to answer that point, but the cross-examination continued. I don't have time to obviously go into it in detail, but would give your lordship some references at page 284, which goes to show one of the dangers the judge was trying to avoid, which is about legal advice, and 285, where the witness had admitted in the deposition evidence that the statements were voluntary and now he was changing his mind. And then at pages 288 to 293, that's where Nigel Roderick explains, basically, he says, well, look, you know what happens at police stations, effectively, you know, this was why I was taking, this is why I gave the second statement. And then, so in a nutshell, I say, well, look, what difference would this have made in circumstances where he was just going to continue to deny making the second statement? Oh, but look at Mr. Roderick, the circumstances of the Allen murder are very similar to the circumstances of the Rampersad murder. How does that assist? The prosecution has already put forward, it's very clear from the prosecution summing up, which I invite your lordships to read, that they're putting forward Nigel Roderick as an accomplice, as a criminal, as a member of a gang. No jury in its right mind would believe Roderick that he was simply an observer on the night of the Rampersad killing. No gang involved in kidnapping and ransoming of people and beating them to death has with them, observers. He's an accomplice. So everybody knows that he is a witness in respect of which serious caution is required. The judge also cautions them about that. So that's why I say, really, none of these additional points are going to help. But I have just summarised four reasons in conclusion why I say that the further cross-examination wouldn't have in fact made any difference. The first point is, in respect of the Allen murder, Mrs. Elder did in fact elicit most of the core facts of that murder, including the fact that the body was found just around the corner from Roderick's house. And those facts are set out in my case at paragraph 33, and I've listed all of the facts. I mean, you couldn't really have extracted much more from a statement than what she was allowed to get in any event. Secondly, as I said, the similarities between the Rampersad killing and the Allen matter don't really take the matter further, because Nigel Roderick was being put forward as an accomplice in any event. The prosecution was saying, well, who else do you expect me to bring to give you evidence? It's going to be someone who's basically involved in these sorts of things and is going to come and turn turn state's evidence. Thirdly, the jury plainly did have doubts about Nigel Roderick's evidence, because if they accepted everything Nigel Roderick said, then all of the defendants would have been found guilty. And they were not. So it stands to reason that the jury were not prepared to accept the detail of what Roderick had to say in respect of who did what. That being the case,
You can't put that too high, can you? Because they didn't agree, the jury. Maybe that most of them did accept his evidence.
it may be that most of them did, but as a whole, his evidence wasn't accepted by the jury as a block, as it were. But yes, some may have accepted it, some not. But when it comes to the appellants, it's clear here that the only convictions this jury was prepared to make were where the appellants had themselves, where the defendants had themselves said something to the police. And in order to have found these appellants guilty of manslaughter, the jury must have accepted in broad terms what Nigel Roderick said happened in the field. And that's where I come on to my final point about manslaughter. But given that the jury, or some members of the jury, weren't prepared to accept Nigel Roderick's evidence about who did what, and relied instead, it appears, on admissions together with what happened in the field, which was backed up by medical evidence, how much difference would it have made if the jury had said, oh, well, look, these murders are all very similar, you've given this kidnapping. Okay. I mean, the jury is already doubting what Roderick is saying, and is only prepared to go on any of his evidence where corroborated. And then fourthly, the main point is, of course, he would have just kept denying it. So how would it have assisted if he just keeps saying, well, I deny it, unless you're going to call the officers. But it's very clear, if your lordship's ladyship reads the exchanges between counsel and the bar, between the bench and the bar, vis-a-vis the judge's decision on cross-examination, that Mrs. Elder was saying from the very beginning, before the ruling, I'm not going to go to voluntariness. Never been a plan here to call the officers. If that's the case, you're already in trouble on Roderick's answer, which is, I didn't make the statements. Finally, can I just take your can I just give your lordship some reference for the manslaughter point? Now, what I effectively say here, so this is my alternative argument. If your lordships are not with me on points 2 and 4, and your lordship ladyship says, well, look, actually, I think the cross-examination may have made some difference, and it may have caused the jury to have more doubts about Nigel Roderick's evidence. In my submission, those doubts would not have extended to shaking his evidence about the date of and the broad circumstances of Rampersad's, the beating of the lady in the field and her burial. And because we looked at the Brown case very briefly earlier, I just need to give your lordships the reference. I think the difference between myself and my friend on this, my friend says, well, look, if I'm right that the judge should have allowed this further cross-examination, Nigel Roderick's evidence is out. And I say, no, that's not right, because this is a case where one has to assess the best case that could have been reached by the appellant had they been allowed to cross-examine Roderick. My lord.
Can you just help with exactly what had to be proved by the prosecution to prove manslaughter beyond what was admitted by Clarke and
Yes. I
And
fear
what,
to do
and what direction the judge, jury were given about that.
Yes. Well, I think in the time available, what I would do is give your lordship some references to all of those points, because I'm not going to have time to do them fully. But what I say is, the first point is just to look at the medical evidence. So the medical evidence is summed up by the judge, volume 3, tab 28, 1007 to 1016. And you will find that the medical evidence was consistent with Nigel Roderick's account as to the broken back, as to the shaking hand once the back had been broken because of the nerve damage, and the foot being higher than the rest of the body. But that's what effectively, to just look at the summing up there. So I say, well, the jury would have accepted that part of Roderick's evidence on any view because it was backed up by the medical evidence. Now, in terms of Clarke and Martin's admissions, please refer to page 1016 in the summing up, where the basic account, and just to be clear, my lords, I'm saying at this stage, you can assume that the jury rejected all of Nigel Roderick's evidence about what happened before the lady turned up at the field. So let's assume, against myself, that this extra cross-examination that was not permitted would have led the jury to basically reject all of Nigel Roderick's evidence about who did what before you get to the field. And I say, just rely on what Nigel says about what happened at the field. Then you have to glue that together, as it were, with the admissions of Clarke and Martin. Forget McGilvery, and McGilvery's off the hook if I'm at this stage. I'm then left with Martin and Clarke. Sorry, it's not a very elegant way of putting it, but I then say to please look at pages 1017, which is the case of Martin, number 6. And then pick it up again, please, at pages 1042 to 1046. And then at Clarke, and then for Clarke, please, at 1069 to 1070. That's where the judge sets out what Clarke says in his statement. And he says he admitted to agree to organise the gun. Someone came for the gun. He was told to patrol the main road by Dollar Rescue, which is a shop. While there, Clarke gets a call that the bread is in the oven. That's the reverse of what Nigel says, but we're forgetting Nigel's evidence at this stage. That's just on Clarke's admission. So he admits organising a gun, he admits knowledge of the kidnapping, he admits that the woman they took was for the money, and that he was patrolling the main road while the kidnapping went on. And then the judge says, if you believe that statement, he was involved in the kidnapping. 1073. Then Martin is at 1082 to 1085. Martin admitted being the driver in the kidnapping. He knew it was for ransom. He drove, stopped the car outside the lady's shop and witnessed the snatch. The others had guns. This is all in his statement. He went to Caxton Bay and dropped off the woman. He then went back without the woman. So pausing there, these two witnesses in their different ways have admitted to being part of a kidnapping. They've admitted it being about money for ransom. They've admitted it involving guns, and they're both saying the woman was dropped off somewhere else to other people. I say then you effectively glue onto that evidence the evidence of Nigel Roderick, that on the very next day, on the 27th, he's up in the field, the woman is there. She's plainly still in a state of being kidnapped, if I can put it like that, metaphysically as it were, and she's beaten up and left for dead. In those circumstances, Martin and Clarke at least are good for manslaughter. And the way the state put the case against the appellants, exactly, I'm going to come to all your points, Lord Legate. I'm going to give you references as to the test that's been met and everything. So the way the state put the case against the appellants is at 1106. That deals with joint enterprise and the requisite tests. Then the prosecution's closing speech at page 955, that sets out how the prosecution was proceeding with this. And then at 971, 973 deals in particular with Clarke, 975 to 977 for Martin. The witness as to the, I'm going to come back to the trial judge's directions as well. The witness as to the kidnapping itself is at page 449. That shows it was violent, involving guns. And then
sorry, did you say 449?
449, yes. That's Mr. Granham's evidence about kidnapping himself, although, my lady, you're quite right to say they didn't see anybody, but the point is it shows it was a violent affair with guns and all the rest of it. And then you come to it's worth just looking as well at the summing up at pages 1106 to 1108, if that's not a reference I've already given you. And then also just to look at how the Court of Appeal dealt with this point, because arguments were made about causation and super intervening event and all those sorts of things before the Court of Appeal and before the board, and the board has refused permission to appeal. But they are at page 1170, where the Court of Appeal sets out the judge's directions on causation and basically says, well, look, they were all involved in the kidnapping and they knew it was for ransom. Things got out of control and she was killed. Well, that's manslaughter.
Mr. Pennington Benton, you're running out of time, I'm afraid. We must hear from Mr. Birnbaum in reply.
Can I just give you some reference to Jogi?
Yes, please.
Jogi restates, as it says in the internal title, restatement of principles. The case is at tab 5 1802-5.
Sorry, reference again.
Volume 5, page 1802.
Thank you.
And I would like, please, your lordships, to look at paragraphs 96 to 98, where it explains what needs to be shown and how causation works. And in my respect submission, there is no basis here for a super intervening event that could have possibly deflected liability, and that's why they're guilty of manslaughter. That's it. Thank you very much.
Thank you, Mr. Pennington Benton. Mr. Birnbaum.
Limited time that remains to me, I want to focus first of all on this alternative basis for conviction. And then if I have time, I want to say something about the mess that the prosecution made. It's important that we grab hold of this fact and we don't lose hold of it, that the way the case was put by the judge, quite properly, was what I would call the old-fashioned pre-Jogi way, which is members of the jury, you look at what the principal did, he's Mr. Boudram, and you look at whether the others were parties to what he did, and you assess that by looking at their state of mind in relation to what they thought or foresaw he might do. If they think he might well commit grievous bodily harm, murder, if they only thought that he might do something less than that, that's manslaughter. Jogi is out of the picture because Jogi is a later case which changed the law and which said remarkably, as I as a criminal lawyer now realize, that for years the fraternity of criminal lawyers and judges had misunderstood the law about joint enterprise. And part of what Jogi says is, it's only one part, is that where you're dealing with manslaughter, you don't really have to bother about the scope of the enterprise anymore. All you do is look at the older authorities and you ask, did the accused engage in something which is objectively dangerous? And if he did, then unless the chain of causation is broken, he's guilty of manslaughter anyway. It's simple. The learned friend is not entitled to retrospectively import that change of the law back into our case. May I say why? Yes.
But do you accept, if you go to page 1818 and paragraph 96,
Yes.
the test there of if he participates by encouragement or assistance in any other unlawful act, which all sober and reasonable people would realize carry the risk of some harm, not necessarily serious, to another, and death in fact results.
Yeah.
But if you applied that test, Martin and Clarke would be guilty of manslaughter.
Yeah. Subject to the issues of causation, and the issues of causation, which are complex in this case, are set out in my application for permission at paragraphs 1225, sorry, pages 1225 to 1226.
But just subject to those issues of causation, that test, on the basis of the evidence of the independent witnesses, the use of guns and the confessions, they're guilty of manslaughter.
If you apply Jogi.
Yeah.
Yes, if you apply. But I'm saying you can't apply Jogi. And may I just very briefly describe the difficulties that defense lawyers have in seeking to apply Jogi retrospectively, where they're saying, my client might have been acquitted if Jogi had been in force at the time of his conviction.
Yeah.
To which the Court of Appeal says, not so fast, Mr. Birnbaum. You need to make out a very, very strong argument that that's so. And it's almost impossible these days. And so the learned friend, who is the prosecutor, who has to prove his case, must surely face a much greater difficulty. Furthermore, if I'm wrong about that, his argument is doubly incoherent. If I've understood it correctly, he says, let us assume that the jury, having heard Mr. Birnbaum's style of cross-examination about this earlier statement, have said, we don't believe Rodrigue about what happened prior to the field of death. Well, if the jury don't believe what happened prior to the field of death, then they don't believe what he said about Clarke and Martin. The prosecution are then back to what Clarke and Martin themselves said, which doesn't include any reference to Boudrum. They never met Boudrum, according to them. What learned friend has forgotten is that he needs Rodrigue to tie Clarke and Martin to Boudrum in order to tie them to Boudrum's killing. You see what I mean? If that link has gone, if Rodrigue is not telling the truth about anything before the field of death, then the learned friend's argument is lost. Furthermore, says the learned friend, the jury must have accepted what he said about the field of death. Well, not so fast. Because in fact, a number of the jury, we don't know how many, were not prepared to convict any of the alleged killers. They disagreed. So the learned friend is in grave difficulties on every aspect of his argument. Can I return very briefly to the point one of my lords made, I think it may have been Lord Leggett, that isn't this really, paraphrasing what he said, all the fault of the prosecution? And how could this problem be resolved justly to anybody, to everybody? The answer is it couldn't, because of the problem that everybody's neck is at risk. It's just impossible to call a man who is at risk of being executed for one murder, convicted of capital murder on one case, in relation to another case in which he's also involved. One of my lords asked the question, well, why not have the trial of Rodrigue first? There's a very good answer to that. Rodrigue wouldn't want that. He would want to delay the evil day when he might be convicted and sentenced to death. And the prosecution wouldn't want that either. Because suppose Rodrigue is convicted and he's sentenced to death, what does he then say? What happens if he turns around and says, right, you commute my sentence or pardon me and I'll give evidence? it's impossible in this situation to do justice to everybody, and someone is at risk of having suffered a major injustice. And the whole of my theme is that these defendants may have suffered such an injustice because their counsel was denied the opportunity to bring out that this man had the talent for elaborate fabrication. And if I've got a choice of one more point that I can make before the deadline hits me, then perhaps I'll make this point.
You've got time, Mr. Burnbaum, and we can run on short. We can run
Thank
on.
you very much. Well then, let me come back. Allow myself a little more leeway. Thank you very much. Let me come back to my learned friend's concession that there was a firm basis for the kind of cross-examination that I am saying should have taken place. Having made that concession, having very fairly, that is the end of his case on whether the judge was right. Of course, the judge would have had a case management obligation, and of course he would have been obliged to protect Rodrigue against any realistic risk of self-incrimination. He done by keeping a careful eye on the cross-examination and by controlling it and saying, as this judge did from time to time, no, you can't ask that. Yes, you can ask this. Mr. Rodrigue, you needn't answer that. So we are then into the area of miscarriage of justice or not. And let me just try to read my almost illegible note to see whether there's anything else that I think I need to say to you. My learned friend seems very devoted to this point, that it wasn't going to do defense counsel any good to cross-examine a witness who was going to deny the allegations. Well, 2 points on that. First of all, it hardly ever happens with a witness like Rodrigue that he says, yes, defense counsel, I admit it, my evidence is all a load of lies. But that's not what you're looking for when you're cross-examining the Rodrigue type of witness. First of all, you're looking for the unconvincing denial. But secondly, you're looking to make your speech. And the best possible point that the defense potentially had against Rodrigue was denied to them. That's not that he was a kidnapper, not even that he was a murderer, but look, members of the jury, at this man's talent for sophisticated and detailed lying against a number of people. Look at the statement of which you have a summary. Those are my submissions. Thank you. Yes, my lord.
I thought the lack of retrospective effect of Jogi was confined by the Court of Appeal in Johnson to cases which had been finally determined, and this case hasn't.
Which cases have been finally
determined?
No. Final determination means by a verdict of the jury. So, in other words, the jury have returned their verdict before Jogi was decided. And if you are an appellant in that situation, you come along and you say, my conviction was unsafe. The Court of Appeal will say to you, not good enough. You have to demonstrate, because this is a change of law case, you have to demonstrate that you had a strong argument that a Jogi direction would have made a difference. Now, it may be that I've misunderstood, my lord,
No,
but I think
it's okay. Thank you.
yes, I think that's the answer to your question. Can I assist on any other point?
I don't think so. Mr. Birnbaum, give me one moment. And you say that that is so in cases which are pending on appeal?
Yes, let me be clear. I'm talking about cases where the defendant was convicted of murder pre-Jogi, and after Jogi, counsel on his behalf comes along to the Court of Appeal and says, would you please declare that this verdict is unsafe? And the Court of Appeal then says, we can't do that because we can't do that unless we are persuaded that he has suffered substantial injustice. And substantial injustice means in this context that you have to demonstrate a strong argument that a jogi direction would have made a difference. And I bear the wounds of having failed to do that, as do a number of other defence counsel on a number of occasions. So it's.
Thank you. I don't think. Yes, my Lady Rose has a question.
Yeah.
Can I just understand where we've got to on Section 44 of the Supreme Court of Judicature Act?
Yes.
Just looking at the terms of that.
Could you give me a page reference, please?
Well, I'm not sure.
Is it in brown? You want a friend helpfully with your brown? Yes. He's much better on page references than I am. Therefore, he ought to win.
It's copied out at 1582.
Right. Thank you. Okay. Thank you. Yes, my lady. Yes.
Yes. So there it deals with the. I'm assuming that this is the test that we're applying, and looking at the different possibilities for the reason why the Court of Appeal, the grounds on which the Court of Appeal can conclude that the verdict should be set aside,
yes.
It's unreasonable or can't be supported having regard to the evidence. We're not in those circumstances. A wrong decision on any question of law, that would be the point about the wrong exercise of the discretion to exclude the evidence.
Yes.
That, or any ground there was a miscarriage of justice, seems to decouple, as it were, the miscarriage of justice ground from the wrong exercise or wrong decision on any question of law, to be a sort of freestanding ground on which the verdict can be set aside, rather than being a proviso to one of the previous grounds. I haven't expressed that very well, but I hope you understand what I mean.
What you mean. This sort of wording reflects what I would call the old-fashioned wording of earlier criminal appeal acts in this country, whereby there were a number of bases for allowing the appeal, and there was always then a proviso. Whatever statutory structure you are looking at, it will always come back to the proviso area. I say the proviso area because the court will always dismiss the appeal if it comes to the conclusion that there has not been a miscarriage of justice. Now, I hope that, and I think my learned friend and I are agreeing about this, that if you have an uneasy feeling that there may have been, I put it in this way, then you ought to allow the appeal. If you say, well, that's all very interesting, but we don't think that there could have been a miscarriage of justice, then you would dismiss it, or in the Privy Council, you would give the humble advice to Her Majesty. I hope that's helpful, and I hope it meets the point you're interested in.
The proviso is
Right.
putting it the other way round. The proviso is that there has been no miscarriage of
Yes.
justice, and therefore, even if there was, for example, a wrong decision on any question of law, the verdict should not be set aside.
That's exactly. That's
yes.
exactly.
I mean, what this section seems to be saying is not a proviso. On the contrary, it's a freestanding ground of appeal, but there has, on any ground, been a miscarriage of justice.
Yes.
So I'm just trying to understand whether you are both interpreting that as meaning that if there has been a miscarriage of justice, then we should set aside the verdict, even if there's no wrong decision on any question of law, or even if it could be supported having regard to the evidence. This is not a proviso point, because the proviso is the application of the proviso means that the jury's verdict is not set aside because there has been no miscarriage of justice. What I'm asking is whether you are both saying that because of this text, the ground that there was a miscarriage of justice can be made out, even if none of the previous possibilities in the previous lines of this section is made out.
Yes. Well, this particular wording is apt to be rather confusing because you have grounds for appeal and then you have a provision, let me not use the word proviso, a provision which says even if there is a ground, you don't have to allow the appeal. And what is apt to be confusing is that the term miscarriage of justice appears both in the grounds and in the, forgive the term, the get-outs. And I think that my learned friend and I are trying to assist you to avoid getting involved in that by saying, look, first of all, decide whether Birnbaum's got a point. If he has got a point, then ask, might it have made a difference to the jury's verdict? And that's how I put it, and I think my learned friend agrees with that. And if that's right, then it does give you a practical way through what is otherwise an exam question, or maybe a question in the Privy Council. I hope that's of assistance.
Yes, thank you.
Thank you, Mr. Birnbaum. Don't think there are any further questions. Well, Mr. Birnbaum, Mr. Pennington-Benton, the board's very grateful to you both for your very helpful submissions. We're also, I should say, very grateful to those metaphorically sitting behind you or just out of camera range. Realise a lot of work has gone into the preparation of the appeal.
Yes.
We will take time to consider our judgment in this case because it's a Trinidad and Tobago case, and that concludes the hearing. The court is now adjourned. Thank you very much.